Okay, good evening, class. This is lecture number 10. So when you look back, probably you suddenly realize you become an expert in probate already. I hope. Not difficult, because so far I have been feeding you guys with the fundamentals as well as some practice. Once you get this accustomed, I think the road is straight and it's clear. So you just move on from your present position, and then you'll be faced with a variety of different prospects. It's interesting because I can see that at least for the next few years, there will be various parts of estate planning going on continuously, and then how you are able to move on will depends entirely on the particular path that you happen to be in. Now, we continue with the latter part, just to wrap up the probate practice, and then I'll give you a bird's eye view of what estate looks like. So you would be prepared as an average probate practitioner, should be no problem. And then after the intermission, we will discuss on the judgment, which is very interesting. Now, for the probate practice, the modern trend in Hong Kong is you must follow the specified forms. So with the checklist that we have discussed briefly last time, you should be able to get to the right track by looking at a few questions as to whether the deceased died testate or intestate. Sorry, those are the facts. Can you hear me? Oh, good. And then the domicile, and then primarily the day of death. Basically, whether before or after 1971, before or after 1955, and before or after 2006. So by way of a process of elimination, probably you should be able to handle the non-contentious probate matters, the bulk of it. I would have thought at least about 80%. Now, one thing that will ensure that you'll be on the right track on probate practice in terms of grant application would be to follow the specified form. So you must pick the right form, and it has been there for a number of years, and by and large the specified forms in the 7 subdirectories are fairly clear, save and except the distinction between foreign domicile and Hong Kong domicile, and also the possible contribution on renunciation in a testate and intestate situation, where some general practitioners will fall into the trap of picking the wrong form in renunciation because of this LA will annex as compared with simple LA. And then, in the past few years, the probate registry has made a very loud voice against practitioners to stop making what the probate registry call a shoddy application, S-H-O-D-D-Y. It's a funny word, but what it means is a very bad application. By not following the specified form, there are various ways to deviate from it. You pick the right form. You pick the intestate form for a testate situation, then you're wrong. And then, even though you have picked the right form, you try to move around. Well, it comes in a certain order, like from 1 to, let's say, 9. And then some practitioners feel like I move paragraph 1 to paragraph 3, and then I move paragraph 9 to paragraph 2, so on and so forth. So the probate registry said, no, you must keep to the order of the paragraphs as it appeared. So they say this is a substantial compliance in the use of the form. And then we have to use enough flexibility to delete the paragraphs which are not applicable. And then, which is more important, make sure that you do not be too creative by citing some funny words and creating funny paragraphs. So the thing for us to remember is, as a start, use the specified form as much as it appears to be. Wait until the next round when requisitions are made. Then you put in additional paragraphs in order to try to explain away the reason why you make the application by saying such paragraphs or statements in the way you appear to be. That would be much better. And so once you are accustomed to these specified forms, once you follow these several points to be aware of, then as a start, you should be looked at and accepted by the probate registry as you have made a substantial compliance with the specified form and the use of the specified form. Previously, it was said that under, I think it's Rule 72, we use the Tristram and Cook precedents as a guidance. Now it has been formally reversed. We use the specified forms, which now should provide for about 95% of the application situation. Only when we run into situations that are not covered by the specified forms, then we may turn to Tristram and Cook. So that is the priority, and that's the source of the preference. That's why in modern days we use more often on the guide that I've shown to your class in the first few lines in the checklist as the authority to back up the way you have chosen to put the wordings, the way you have chosen to have a particular family members as the applicant. So that is the thing that we should be aware of and we should follow. Last time we have already mentioned about this at the close of the lecture. So we have two words. One is called a prefix. The other is called the suffix. Prefix is the first letter in the form. So you see C, citation or caveat. You see F, foreign domicile. You see L for interstate. And you see W as a state situation, so on and so forth. So you look at the first letter, which we call the prefix. So there are 7 classes put into the 7 directories or subdirectories in the specified form. And then for the checklist forms that we have discussed is 1.1a, for instance, or 1.2a. All this, the small a at the end is a suffix. Usually we only find the suffix when it comes to the choice of forms to be the oath. The other specified forms, such as the renunciation or the other kind of consent, it doesn't contain the suffix. So as we have moved along for quite a number of years already, so basically we are moving towards the suffix using a, meaning after 2006, more often. That should become a norm. We have already mentioned this, and you have seen it. By this time, it should not come as a strange stuff for you now. So this is the explanatory note that you can see leading to the choice in a particular subdirectory that comes down below. So as I said, you basically, for general grant application, you pick L and you pick W. And only until you move forward, then you deal with some special circumstances, such as grant the bonus non or something like this on a secondary grant, which is not a matter that we should cover in this module. Once you get there, now that you guys have been very familiar by using this online service in your iPhone, then you should be able to pick it up directly without having to move around. So this is what it should be. We'll talk about the use of the forms, the number, W1.1a, W1.1b, so on and so forth. When you look back to the checklist in section A, then what it says in this PowerPoint would make some sense to you, I hope, by now. Once you're not frightened by all these numbers, then it would mean that you should be fairly competent in handle the general non-contentious grant application. We have mentioned about the use of forms on a particular situation. So these are on the intestate stuff, L. Then, since we're talking about non-contentious probate practice, it's by definition that these contentious matters are being included as part of the non-contentious matters. Caveat has become a very popular small tool that people find it very cheap, inexpensive, and so they use it very often by these financial institutions. Those who would like to get some advantage in terms of entering a caveat, stopping the normal grant application in order to create pressure for the grant applicant to accede to their request for that payment as soon as possible. And I've told you that that's the priority is creditor. Creditor in grant application is almost at the bottom of the list of priority. So they have no priority at all. So therefore, only in terms of clearance, then you clear off the caveat in the normal circumstances by the caveat procedure, by asserting the normal priority under Rule 19 and Rule 21, then the problem will be solved. Unless those of you who are not familiar with this procedure and being victimized by this process, so you will be compelled to enter into some kind of contract or letter of undertaking for immediate or prompt settlement of the outstanding indebtedness, as well as being forced or compelled to pay expensive legal costs. So all these general creditors, like credit card, like outstanding management fee, these guys are making full advantage of this procedure in a way which is not professional. So if you are in practice in future, once you find that there is this caveat, as I said, the normal way is to give them notice. You can give a letter first, and then you give what we call a warning, and then that will stop the whole fight, because this is not a normal use of the caveat procedure. But whereas in other situations, when there is fight for priority, then you should realize that, okay, anyone can enter a caveat. Anyone can enter. There's no need to say anything, except that the caveat has to be drawn up and issued by the probate registry. You draw up the caveat, you file the draft caveat, and you have it approved by the probate registry. I think the only thing that they should see is that this is the person who has died. That's it. So, each caveat lasts for 6 months, subject to a right of renewal for indefinite times. So you can enter caveat like for 10 years, you can enter 20 caveats. Each time for 6 months. Before it expires or after it expires, it does not matter. As long as in the meantime no grant has been issued. If there is a pending grant application, you can still enter a caveat. But after a grant has been issued, then probably the caveat will be meaningless, unless it comes to administration of unadministered grant by way of the secondary grant, like grant de bonus non, that you don't have to worry. The thing that we need only to be aware of is these 3 stages. First, you enter a caveat. Then the other side, which is normally the grant applicant, being notified by the probate registry that the grant cannot be proceeded with until and unless the caveat has been removed. Then the grant applicant will file a warning. Once you file a warning, the grant applicant attains a new capacity called the person warning. With that, it will be up to the caveat, the one who entered the caveat, which we call the caveator. It will be up to the caveator to decide whether or not enough is enough, or I have decided to move on, to make this a more serious game. If that is the case, the creditor will need only to file the third document, which is called the appearance. So there are only 3 documents involved. 1, caveat. 2nd, warning. 3rd, appearance. All we need to remember is, once an appearance has been filed, then either we need a comprehensive caveat proceedings, or we may just start a full-blown probate action with the court by invoking on Order 76. So only 2 routes. Either within the caveat procedure, so that the master will decide whether or not this caveat and appearance are to be removed, or the master will give an order to say, all right, you may start a probate action. Alternatively, it's a second option, which is you don't care about this caveat stuff. You just go ahead, issue the probate action, the Order 76 action, and then include a prayer to vacate the caveat and vacate the appearance, so that the person approved by the court will have the permission to apply for a grant under the normal circumstances. So the general picture would be, after all these disputes, either under the caveat proceeding or either the contentious probate action, then the whole thing will kind of subside and resume back to normal, so we can proceed with the normal non-contentious grant application again with the probate registry, as if this is a day one application where nothing has happened. So this is the caveat procedure. The other thing about caveat, sometimes it's being used as a preliminary steps involved in another set of procedure, which is called citation. Citation, as I've told the class, there are 3 types. But generally, as you issue a citation, well, you will also have to file a caveat as a preliminary procedure. So all these are just to enable the caveat and the citation to go parallel to each other, so that this, like a storm in a teacup, can be resolved one way or other. Either A will be given a grant, or B will be given a grant. Different camps. Okay? So caveat and citation are useful small tools in our grant application, and sometimes, as I said, they work in pairs, as I've just outlined. The other thing I want to draw your memory or attention to this is the interesting exception to the general grant, and it is strictly speaking a kind of secondary grant. As I've told you, normally you will need a secondary grant when the first grant was issued, but the estate remains somehow incomplete, either wholly or partially. We call having unadministered estate. So normally you need a secondary grant. The term is a grant de bonus non, DBN. With a grant de bonus non, meaning a secondary grant, We just move on, apply for a grant in favor of a new person, and complete with the estate administration. So strictly speaking, there are two grants applications. Chain of representation we have explained before, so I just explained this by way of revision. So A died, A is a testator, died having a will named the executor B. B applied and was issued with the probate. Let's say B is the sole or last executor. However, B, for some reason, was not able to complete the estate administration, and somehow he died normally. In order the chain of representation can occur, so B also died estate. B also make a will, having named the C. So in the situation of C, apply for a grant of probate of B's will, then the moment when the will of B is granted in favor of C, then this legal consequence of chain of representation will appear in respect of the unadministered estate of A. And I stress now that chain of representation is something to be done with this legal effect that would be imposed to the two estates. C, in our example, cannot pick and choose. Cannot pick and choose. It's a take it or leave it situation. So C must consider and make up his mind. If he is determined to deal with the estate of B, as well as to deal with the unadministered estate of A, then C can move in and apply for a usual grant of probate of the last will of B. So that is the differences. Chain of representation is good because application is fairly clear and straightforward. Simple application for grant of probate. And it also has, if you recall, it has the additional benefit of overcoming the possible confusion or dispute or delay arisen by reason of the difference in domicile. So you don't have to worry about all this. So that is a way in your future practice, try to look at it and see whether wills can continue to be made to the second generation in order to take full advantage of this chain of representation. We have explained this before, so I don't have to do it again now. Now we talk about estate administration. Grant application, the whole purpose is to administer the estate. All right? Is to administer the estate of a deceased. When we say estate, we mean those assets that belong to the deceased beneficiary. Whether it was held in the name of the deceased or whether it was named under some third party for and on behalf of the deceased. Then, Hong Kong is a place that in order to administer the estate, you must apply for a court order, which is called a grant, in order to be given the authority for estate administration. The Court of Hong Kong has authority to deal with and supervise estate administration in respect of assets located in Hong Kong. This is to deal with the property. Then, the more complicated issue is the supervision on the job to be done by the PR, the personal representative. The personal representative, first of all, will have to decide on the scope of his power, authorities, as well as duty. This is to follow the law. In Hong Kong, usually is Cap 10, Probate and Administration Ordinance, Cap 29, the Trustee Ordinance. Then, if we move further, if the deceased died with a will, then whatever is provided in these two statutory ordinance is subject to expansion or limitation, as may be provided under the will, if any. Now, I have mentioned to the class already, the law of Hong Kong in fact goes beyond the statutory provision under the law. It's extended to cover the common law, which is to be dealt with by judgments and decisions, as well as also covered by the private international law. So all the three will form the laws of Hong Kong. Now, as far as administration of estate is concerned, basically, we mean start from where the grant is issued, if this is not probate. Technically, you can ask, if this is executor, technically, he is given the power under the will, so his authority starts the moment the deceased dies. The grant of probate subsequently is just to give it the formal recognition and evidence. Number one, this is the last will. Number two, the appointment of executor is genuine. In terms of the commencement of the duty and the authority, without any proof, will commence at day one. Then, in respect of administrator, whether with the will or without the will, the authority commences only at the date of grant, not before. So there is a vacuum. The vacuum in terms of day one deceased died, day two the grant is issued. This vacuum theoretically is filled by the law under Cap 10, providing that the official administrator will have the authority to be in possession of the property of a deceased. Hence, we have discussed this term as automatic vesting with the OA. And then when the grant is issued at day two, there is what we call the automatic reinvesting from the OA to the grantee. So this is a fine legal point to cover the legal vacuum in terms of when there is the personal representative who is not an executor. the authority starts at day 2 when the grant is issued, then the administrator will commence the job. Basically, is to get into the property. So you collect the property. You collect the property. You get in the property. You convert them into cash. Okay. Collection of assets. Okay, there's a house. Get into the property. Go into the premises. Conversion of property. If the assets are not by way of cash, you change them, literally all of them, in order that after this doctrine of conversion, to turn them into form of money, cash. This is still the gross estate. This is still the gross estate. The process of collection of assets may means there will be a lot of litigation, and in order to collect what actually belongs to the deceased, so you turn everything into money. This is still the gross estate by now in cash after this problem, this doctrine of conversion. Convert them into cash, then use the conversion. What is remaining now in cash is to be applied to settle all the liabilities, which will include usually the debts, the other liabilities, the testamentary and administration expenses. This generally will mean the money involved in applying for a grant, the money involved in collecting the assets, and the money involved in payment of all these expenses and liabilities and tax, if any. After this process, the net, sometimes we call this the residue, what we call the residual estate. On this residual estate, if there is Cap 1 application, this is now changed to the name in the form of net estate and subject to additional 1 order. And then when this is a will, you turn this residual estate by payment of the non-residual gift, then the balance is the residual estate, even on a testate situation. Now, when the balance is now available, this is called the residual estate. Theoretically, they should all be in cash now, but in practice, not necessarily. Not necessarily, because not all the estate will be, not all the property under the estate will be required for settlement of the indebtedness. Therefore, it will be possible for distribution of the residual estate or distribution of the estate in layman terms, sometimes by way of this doctrine of appropriation. I distribute the estate to you. You are entitled to, let's say, X amount. Now I have some specie, so I tell you, I want to seek your consent. I give you a ring of your deceased father as part of your entitlement. I don't want to sell them. I just give you in the particular specie with the amount that we agree. I give you the balance in order that you have your entitlement in full. So appropriation, and that may also come in would be additional other elements that we have talked about briefly on the sections of trust, such as the advancement and also other kind of payment for the support of the beneficiaries. But basically, we say in the normal process, once all the assets have been collected, once all the debts have been paid, then to be in a position to make distribution, this will be the estate administration as defined. Full stop. But there are various reasons that distribution cannot be done, such as you cannot find the beneficiaries, such as you cannot obtain a valid receipt because there are minority interests. So all this waiting period for the disposal, this waiting period, then theoretically the administration of estate process has already been completed, and the administrator or the executor at that juncture is already transformed into a different capacity, which we call now the trustee. There is a fine difference between administrator, personal representative, and trustee, such as if the residual estate is still in the hand of the personal representative and he dies, then there is a need to apply for a secondary grant, which we have just illustrated. The grant of bonus non or the chain of representation. But if the balance estate is already now awaiting for distribution, and the capacity is now changed from the personal representative to that of the trustee. Now, this changing or transformation of the capacity usually is to be done by way of an assent, A-S-S-E-N-T. Assent can be done informally or by conduct. This refers to movable assets, such as cash. However, in respect of immovable property, then there is required by law that assent must be done in writing. All right? In writing. So this will change the capacity in a way that one can find clearly the change of the capacity. So if the personal representative is now holding in the capacity as a trustee, and he holds as a trustee, and he died, then this waiting period is only occur pending final distribution, already exceeded the estate administration. In that case, we only need to appoint new trustee. We do not need to apply for a secondary grant. So we will need to apply for a secondary grant only if estate administration is not yet completed. If it is already completed, but final distribution is however pending, on this change of capacity, you don't need a secondary grant. All you need is to apply to appointment of new trustee, which has nothing to do with grant right now. The application is under Cap 29. not under Cap 10 anymore. During this process of administration, we have various stuff need to follow usually. If we want to get a direction from the court in terms of estate administration, we would apply to the court for what we call a federal order, BEDEOE, under Order 85. We just mentioned it just to complete the elementary background. Federal application is under Order 85. Generally, you need only to remember this, is to seek the direction of the court as to whether or not something should be done, and if so, in what direction. So if you are not clear, things are complicated, and the beneficiaries are in dispute, they are pointing and accusing finger on the personal representative, the normal and best way is to simply ask the court for direction. For instance, to sell or not to sell a property at a price. Some say no, too low. Some say, well, too slow. Okay? They are having different opinions. Personal representative will then ask the court to give a direction. Can you sell it once? You sell it at the price of, let's say, 5 million. Once that direction by way of court order is given, then the personal representative will be safe and protected to proceed as ordered. Okay? This is on administration of estate. So once the estate is now being collected and converted into cash, then you are in a position to make distribution. But before you move into this, you need to find out what are the liabilities that require to be paid. In order to do that, you see that there is a simple procedure called Rule 68 public notice, which we'll discuss, and I expect you guys will pick up this small skill. To give a public notice so that other beneficiaries, other creditors, if they feel that they have a genuine claim on the estate, they will be given a deadline for them to make the claim to the personal representative. And on the expiry of the period, then the personal representative may then proceed on the basis that the creditors or the indebtedness are limited to those that have come to his knowledge. He doesn't have to worry about unknown debts. He doesn't have to worry about unknown liabilities. So this is the benefit of Rule 68, one of the most inexpensive ways to be handled by you guys as a matter of cost if you are dealing with probate and administration of estate matters. And then, when all the debts are paid, then you'll be in a position to make distribution. Make distribution of the residual estate to the beneficiaries. Rule 68 also has the additional benefit to invite unknown beneficiaries to come in. If no other beneficiaries come in, then the personal representative will be in a position to make distribution on the beneficiaries as known to him. If there are minority interests, there is a waiting period. Other than that, the personal representative will just proceed with the law, or as may be limited or expanded under the will. Similarly, there will be waiting period if under the will, I will give half of my estate to my son, conditional upon his attaining the age of 30 years. So even though all the money is in place by way of residual estate, you are bound by the terms of the will so that you cannot make immediate distribution. You have to wait for, let's say, 10 years. When the designated beneficiary actually attained the age of 30 years as stipulated under the will. So these are waiting periods. There are other problems. Now, I have said Rule 68 protects you from unknown beneficiaries. But there are also problems when there are beneficiaries known to you, but you don't know the whereabouts of the beneficiaries. He hasn't been missing for a long time. Then the law, in suitable circumstances, will be available to assist this fact of the estate administration by way of what we call a Benjamin order. Now, I've just mentioned to you there is a better order. I've also mentioned to you there is the Rule 68 order, and this is the third order which I now draw your attention to, which is called the Benjamin order. The Benjamin order is an application to the court to say that a missing beneficiary, a known but missing, whereabout missing, beneficiary have been missing for a relatively long period. Usually the minimum is 7 years or more. I say 7 years because there is a presumption of death for someone missing for 7 years or more. So here, some of the known beneficiaries, for example, the sons, some children, are missing. You know that he has got a son. You don't know where his present whereabouts. You don't have the death certificate. Like the case of Walter Quay, well, presumed death. If he is a beneficiary, no death certificate, what can you do? So you produce all the evidence to establish that this beneficiary is a beneficiary. He's a known beneficiary, but he has been missing for a considerable period for more than 7 years. Invoking on the doctrine of presumption of death, you ask the court to give a Benjamin order so that the personal representative will be given the permission to make distribution of estate as if the beneficiary, this particular beneficiary, has died before the deceased, with the additional rider to defeat the per steplis rule, meaning he died without leaving any issue. So that no need to distribute the estate or that part of the estate to this known but missing beneficiary. So this Benjamin order is to enable the particular kind of doctrine of left that we have discussed before. Presume that he has died without issue before the decease. Remember, this is just for the protection of the personal representative. if some days later the beneficiary shall reappear again, there is the doctrine of tracing, T-R-A-C-I-N-G. Any beneficiary is entitled to trace the beneficiary who has obtained a wrongful larger share. So this is what we need to understand about on general estate administration. Having said that, the beneficiary, unless and until the estate administration is completed, then he can ask for distribution of his share. But before the estate administration is complete, he has a right only to compel the personal representative for proper estate administration, together with information as may be supplied from time to time, which is by way of the estate account. He cannot assert that he has any right in the estate of the deceased. This is what we call in law an inchoate right, meaning a right which is uncertain. The basis of this worry goes back to what appears here, as well as the other doctrines that we have discussed before, which is the doctrine of abatement and the doctrine of redemption, meaning the estate in question may not be available or may not be available in the full share in order to make distribution or to make the gift. The worst case scenario, however, is the estate may not even be enough to pay off all the debts. If that is the case, then we call the deceased died, resulting in an insolvent estate. If this is an insolvent estate, meaning all the assets are required to use to pay up the indebtedness, and it's not enough. That being the case, none of the beneficiaries that we have discussed so far, whether testate or intestate, shall have any right or claim on estate administration. Similarly, has no right to claim any distribution of the estate. It's none of their business now. All this priority on inheritance that we talk about have become meaningless because this is insolvent. If that should happen, if insolvent estate should happen, then it will be for the creditors to claim proper administration of the estate. Generally, two matters needs to be remembered. Number one is this would be similar to bankruptcy. In bankruptcy, we have receiver, and then we have all these different types of indebtedness. Secure creditor, ordinary creditor, deferred creditor. All this generally we say as provided under the rule of bankruptcy. The general situation applies. The second factor that I would like the class to remember on this insolvent estate, which in practice will be of some significance. Insolvent estate administration, there is, apart from what we talk about to follow the rule of bankruptcy, is there are two other previous prior rules which have a overriding and binding effect, which are important, which defeats the rights of the creditors. Number one, it is the official administrator's expenses. Official administrator, I have mentioned to you about this automatic vesting, remember, interstate, day 1 and day 2, grant not yet issued. Official administrator is given the authority on the automatic vesting of the property, and sometimes in this process, costs and expenses will be incurred by the official administrator. In order to deal with the estate during this interim period, the law says OA has the first priority. Okay? So this is rule number 1. Rule number 2, which is of particular significance for you guys, even though a person died with an insolvent estate, rule 2 provides very clearly all the funeral and administration expenses have priority before the application of the normal rule of bankruptcy. So in other words, what we talk about the creditor, deferred creditor, preferred creditor, ordinary creditor, their priority are all downgraded in order to give first priority to OA reimbursement as well as funeral and administration expenses. That means if someone comes to you saying that my dad has died, well, he has more debts to pay and he has less assets available, don't worry. You can still act for him. You can still arrange for the funeral expenses to be paid, and you can still apply for a grant, and even to the extent of collection of assets. All this expenses, including legal fees, reasonable legal fees, will rank priority number 2 in this insolvent estate. Only when there is a balance available will the balance then be available for payment under the rule of bankruptcy. So therefore, if you run into a practical situation like this, don't worry about this. Give advice to your client to proceed with the burial or the cremation, as well as the normal administration of estate. What he is obliged to do is only to give a estate account and hand over the balance of the assets after payment to OA and after payment of funeral expenses and other administration expenses. So if there is any more left over, then hand over to the trustee in bankruptcy. Okay? I don't propose to go in further details on this area because that goes beyond what we need to understand at this module. Order 85, I have already discussed about this. Rule 60, and in fact it's Rule 60A. Please add an A at line 4, Rule 68, public notice. Federal order, I have explained, this is a federal order, and Benjamin order is the one that I've just mentioned, so by now you should recall. Estate account, vesting of property. The only other item is on the removal of personal representative. I just mentioned to you that there is such thing as removal of personal representative. Again, this goes beyond our module. The only thing you need to remember is this last item, in fact, becomes a very popular item in terms of disputes on estate administration to practitioners. So there are a lot of application for removal of personal representative, as well as for revocation of grant. But all this, they are there, but you don't have to worry about this. You just need to know that there is something called removal of personal representative. Now this is the Rule 60A, public notice to claim. This is something that I think I need you to remember, because I expect that you guys, as a probate practitioner, should be able to handle this independently. Not difficult. You need to pick up this know-how and handle this without any problem. Therefore, it comes out quite frequently as small items in examination. This is by way of ex parte application. The purpose is to invite creditors as well as beneficiaries to file their claims to the personal representative. This would involve some beneficiaries who live across the border, or some creditors which is unknown to the deceased or deceased members. The time to send in the claim is limited to 2 months upon the expiry of the public notice. So time starts to run not on day of death, not on day of application, not on day of first publication of public notice, but on the last day of the publication of the notice period. The benefit is to enable the personal representative to proceed on administration on the basis of any response to Rule 68. Now, if you still have a mind to remember, you'll remember that we talk about the statutory trust. Then Rule 60 has something similar that I want you to remember. They are similar in the sense that they are not by law violating or defeating the normal process of estate administration, but they are there to produce something to facilitate the administration of estate for the protection of the personal representative. They are not giving additional protection to the beneficiaries at all. They are just protecting the personal representative. For the statutory trust under Section 5, Cap 73, protect the personal representative because the minors are unable to give the necessary discharge. They are not able to sign off receipts because they don't have the legal capacity by the fact that they are under the age of 18 years. As to Rule 68, again, is for the protection of personal representative, because, well, there is a limit that the personal representative is expected to know precisely who are all the beneficiaries, as well as who are all the creditors. Things are happening secretly. So the law provides under Rule 60A for this aspect of protection of the personal representative. effect is creditors not file the claim within the 2-month period, or unknown beneficiaries, they will have no claim, and they will have no right to sue the personal representative. This is the ex parte summons. All these are in specified form. So you go to the specified form, they are there. So you file the summons ex parte or the ex parte summons. These are the wording, and this is on the basis of a sole executor. You file this to the probate registry, and then for creditors and others to claim, you file a draft order. The draft order, the only thing required is a 2-month period. More importantly, the 2-month period after placement of 3 public notices. One is the Gazette, the other is the English newspaper, the third is the Chinese newspaper, all in Hong Kong. The law does not require the 3 notices to be published all within the same day. But the legal effect is that the 2-month period starts at the last day of the notice, the last notice to be published. So if you have it published in more than 1 day, so you have to wait for different dates. So therefore, we normally do it all at the same time. And because the government gazette mostly published on Fridays, so all this will be published on Fridays. So this is an example notice in English and in Chinese. So all these are in the PowerPoint. And then the last slide before we take the break is this 3 time elements that I want you to pay attention. Distribution, not within 12 months from death. Cap point 1, no distribution within 6 months from grant. 60A, not within 2 months from the expiry of the public notice. So these are the time elements that I want you to be aware of. The first one comes from death. Within 12 months, no need to distribution. No one can compel. The second and the third are counting from the date. One is from date of grant. The other is from date of the expiry of the notice. Okay, so this is all we need to talk about. Now we take a break, and I think they have a brief questionnaire to ask you to